All or almost all lawyers want to be professionally responsible. But what exactly does it mean to be a professionally responsible lawyer? A natural answer, one that's often given, is to follow the rules of professional conduct. But that answer, in my opinion, is inadequate for a number of reasons. First of all, the rules of professional conduct are very general, but their application to specific problems that lawyers face is often unclear. Take this situation. Suppose you're representing a client and the client's deposition is being taken. At the deposition, the client is asked whether he has had an affair within the last 6 months. The client answers no to that question. But a few days later, the client calls you up and says that he's troubled by what he did at the deposition, that it's not correct, that he hasn't had an affair, that he has in fact had an affair, but that the affair was terminated some time ago. What are your ethical obligations in this situation? The rules of professional conduct say that if a lawyer comes to know that a client has offered materially false evidence, then the lawyer has an obligation to take reasonable remedial measures, including, if necessary, disclosure of that to the appropriate tribunal. But is this testimony material or not? It depends. Depends on the nature of the suit, depends on a variety of circumstances. The lawyer may or may not have an obligation of disclosure, depending on those circumstances. The exercise of judgment is called for. And what would be a reasonable remedial measure? Is it sufficient to correct the statement on the errata sheet for the deposition if the client has not already signed the deposition? These also are questions of judgment for the lawyer. There's a second reason why following the rules of professional conduct is not an adequate answer to what it means to be professionally responsible. And that is, many of the rules grant lawyers professional discretion. A lawyer can act in any one of a number of different ways and still be in compliance with rules. Probably the most prominent example of this is the confidentiality rule. Lawyers have a broad duty of confidentiality to their clients. However, Rule 1.6b states a number of exceptions to that duty of confidentiality, including situations of harm by the client to either the financial interest or the health or life of another person. But the comments to the rules are quite clear that lawyers have discretion as to whether to reveal this information or not. And a lawyer does not violate the rules of professional conduct if the lawyer chooses to reveal, and one of the exceptions applies, or if the lawyer chooses not to reveal. It's a matter of discretion with the lawyer. There's a third reason why the rules of professional conduct or following those rules would not be a sufficient answer to the question of what it means to be professionally responsible. And that is that other law beyond the rules of professional conduct must often be consulted to determine what a lawyer's obligations are. For example, Rule 1.1 says that lawyers have an obligation to be competent. But what does it mean to be competent? In the last 10 years or so, the impact of technology on the practice of law has been significant. In fact, the ABA Ethics 2020 Commission, one of its principal goals in reviewing the rules of professional conduct was to determine whether changes needed to be made because of the impact of technology. And one aspect of the impact of technology on the practice of law is the growing importance in litigation of electronically stored information, ESI. ESI can cause great expense to lawyers who have to produce such information. It can be a treasure trove of information by lawyers who are seeking to obtain the information. One of the concerns with electronically stored information is that a party that produces such information, often in huge quantities, runs the risk that the party may reveal accidentally privileged material, either material that is subject to attorney-client privilege or to work product. What does the duty of competency mean with regard to that risk? Lawyers need to be aware of the need to enter into clawback agreements with opposing counsel or to seek court-ordered clawback agreements, all of which are allowed by the rules of evidence in the federal courts. State courts may well be different. So this is an area in which knowing that you have a duty of competency is not sufficient. More detailed knowledge of a particular area, in this case the rules of evidence, is required in order to be able to comply with your duty of competency. And finally, the rules of professional conduct are incomplete. The rules deal with many aspects of the practice of law, but they ignore a number of important issues. For example, one of the great difficulties that lawyers face in practice these days is to determine an appropriate balance between their personal life and their professional careers. How do you determine that balance? The rules of professional conduct have no guidance at all on that. This is something that lawyers must consider on their own, often without any guidance from the rules themselves. I've devoted my professional career to helping lawyers become more knowledgeable and to exercise good judgment when dealing with issues of professional responsibility. I've argued in writings that I've done that lawyers need to develop what I call a philosophy of lawyering. A philosophy of lawyering is a set of general principles that lawyers can use to guide them in dealing with difficult issues of professional responsibility that they may face. I invite you to visit my websites to consider some of the writing and some of the activities that I've engaged in. My two websites are nathancrystal.com and my law firm website cgcfirm.com, cgcfirm.com. I hope you will find these useful, and I'd be happy to talk with anyone about these issues of professional responsibility to which I've devoted my